Welcome, Jordan. It's so nice to get a chance to meet with you. Jordan is the Assistant Attorney General in the Privacy Section of the Enforcement and Public Protection Division at the Connecticut AG's office, the Attorney General's office. He served there since 2023. In his role, Jordan works exclusively on matters involving consumer privacy and information security, including multi-state data breach investigations and enforcing compliance with the Connecticut Data Privacy Act. We're really lucky to have you, Jordan, especially because you're going to be bringing in the technologist standpoint and really connecting the dots between what's in a law like the Connecticut Data Privacy Act and how it can be actually enforced and what sort of rights consumers have with regard to the law. So I'm really excited to kind of bring this together and share with consumer residents as well as others in other residents in other states what this looks like uniquely for Connecticut. So welcome. Thank you.
Hi, Divya. Thank you very much for having me and inviting me and Michelle on to speak about the Data Privacy Act, but also universal opt-outs specifically. I think it's incredibly important that we discuss these issues and data rights generally, and that this is shared with consumers to kind of keep that conversation going.
Absolutely. So Michelle did touch on some of the changes happening with Senate Bill 1295. My understanding is that the CTDPA and the implementation of the Global Privacy Control, or the Universal Opt-out Control, are designed to give Connecticut residents more control of their personal data. And I want to dig in a little bit further as to what that universal opt-out control, we're going to call it the universal opt-out. In other states, it may be called the global privacy control or other universal opt-out mechanism. There's multiple ways to reference the term. But I'd love to learn from you, in your own words, what is the universal opt-out control? What does that do? And how does it really have a role to play with regard to the broader state of Connecticut's Data Privacy Act?
In my own words, the universal opt-out process is a simple way to tell websites that you don't want information about you to be sold or used for targeted advertising. By sending an opt-out signal as you use the internet, you really remove that constant burden to opt out at each and every site or service that you visit. This really creates a privacy protective internet, and it allows consumers to regain that control over their data that, when you talk to consumers, it's almost like just a matter of course that we don't have a lot of control over our data. And this provision of the Connecticut Data Privacy Act really fights against that and kind of shifts the dynamic toward businesses that need to respond to the signal.
Just to explain that through one slide to give the audience in a nutshell perspective, the universal opt-out control can do a couple of different things. It provides the consumers enhanced privacy and control through reduced targeted advertising, increases transparency, so a consumer can now see exactly when they're being tracked and by which websites, and can turn off tracking individually as needed, as well as it's a one-stop shop. So they can also turn it all off at once, or they can go in and select to determine where they want personalized advertising, where they don't. There's also potential for more of a private search experience, which is definitely as a resident here, I feel like that empowers me to feel more confident in the search behaviors I'm engaging in, and I don't have to feel like I'm going to be tracked all over the internet. If I search once for a kid's activity, that's not going to follow me all across the board. And then changes to website functionality. I know businesses really have, and we're going to talk more about how businesses are impacted by the changes here, and just a more streamlined opt-out process. But I'd love to dig a little bit deeper, Jordan. So Connecticut did have a major change to its data privacy law through Senate Bill 1295. I know Donna Frazier and Michelle Lucan just touched on this new law and some of the sweeping amendments to the law. Does Senator Maroney's recent legislative update make any changes to the universal opt-out control that we should be aware of?
Short answer is no. Though, to be sure, Connecticut enacted many important amendments to the CTDPA. Connecticut's universal opt-out rights have been in effect since January 1 of this year. And in this area of data privacy, in our work, we've really been focused on the educational outreach and enforcement.
Excellent. And so can you dig a little bit more into the two sides of the equation? So we've talked a little bit about what this looks like for consumers and we'll share exactly what it looks like for a consumer from the back end, on the website, the code that goes in and how how advertising is completely blocked after they click the buttons. But can you share from a business's perspective, what do they have to do to, update their website to be able to ensure that this opt-out control is enabled?
I'm happy to. So I'll start off, I'll talk through really the impact on businesses, and then I can touch on consumers and the practical impacts there as well. So for businesses, first and foremost, if a business is covered by the Connecticut Data Privacy Act, they're required to respect consumers' data rights, including those sent from a universal opt-out mechanism. In large part, really, this means configuring your online presence to respond to a GPC signal. It's the best. The GPC really is the best and really the only universal opt-out signal that's been recognized first by California. And this was famously in a tweet in 2021 with the then Attorney General Becerra tweeting out reference to the GPC. And then in California's privacy settlement with Sephora. And later it was recognized by Colorado through their universal opt-out shortlist. And then at the beginning of this year, in Connecticut, when our provision came online, we issued several press releases announcing the universal opt-out requirement and also citing to global privacy control related resources. And then more practically, for businesses, they must set up their website to respond to the signal. There's clear-cut implementation guides on the Global Privacy Control's website, which explains how to do this. And our office, and this was actually in conjunction with our colleagues in California and Colorado, we also released a video tutorial which explains how to set this up. And that's on the Connecticut Data Privacy Act FAQ page as well. And it's also worthwhile to note that most websites for mid to large size businesses use a consent management platform, commonly referred to as a CMP, to handle their privacy related requirements. And we found that a lot of these platforms actually provide reception and proper responses to the GPC signal as a service to those businesses that use the CMP, provided they actually, keep up to date with each state's requirement as they come online. Now, on the consumer side, we found that it's really about, at this point, education and building comfortability with using a browser settings or adding an extension to your browser. For a browser like DuckDuckGo, the GPC signal can be sent by toggling a feature that's provided in the settings for DuckDuckGo. So when you're on the browser, you just go to settings and you can walk through how to set it up there. But on a browser like Chrome or Safari, that really covers the majority of the browser market, they do not themselves support the GPC signal. And so you need to add an extension. And there's a variety of extensions out there. Some are Privacy Badger and Opt Me Out, which will then send the signal from the browser. Our FAQ page also provides a very straightforward 2-minute tutorial, which walks through how you can begin to utilize one of these browsers or browser extensions and send the GPC signal. For consumers, this is really about where you can begin to opt out automatically. You cover a broad spectrum of businesses. And so as you interact with the internet, you don't have to kind of consistently keep this opt-out process front of mind. Your browser is sending that signal out for you after you've set it up. And it removes that need, which we think is a big step forward in utilizing these rights.
Well, but it's really a 2 or 3 step process, very easy. A few clicks, download the extension from a consumer standpoint, download the extension, and then you select the appropriate, you see all the trackers that are there, and you also can, with one click, opt out all the way through all the trackers that you feel you want to disable for that site. And I actually have a slide where I decided I was curious and, wanted to see a side-by-side comparison of, what would it be like in Connecticut to do this using Privacy Badger, and what would it be like if I wasn't in Connecticut? So I have a nice side-by-side comparison here that shows, for somebody who's curious as to what this would look like from on the back end when it comes to comparing the tracking that's happening. On the left, you'll see here that, there's a screenshot when tracking is disabled altogether and the universal opt-out extension is being supported. And you'll see the URL there says don'tpolicy.txt. That specific code makes it clear that this file path represents the do not track compliance option. And then on the right is what it would look like on the back end if that screenshot of when the trackers are present. So it's a really nice side-by-side comparison of tracking versus no tracking for the layman who needs that additional support. Jordan, you and your team have worked diligently to ensure universal opt-out control is understandable and democratized to ensure consumers are really able to see the value and can start using the opt-out control right away. There's a plethora of resources that we've chatted about. Have you all received feedback from Connecticut consumers on what challenges have been raised so far? And can you share about the feedback that's been raised?
Yes, we have. And really, I think the most significant challenge is the current limitations of the GPC signal and how it relates to some of the most common ways consumers interact with the internet. By and large, we know consumers are using the internet through mobile devices, namely smartphones, and they're using apps on those smartphones. And we all know sometimes it feels like everywhere you go, we're encouraged to use an app tailored to a specific event or service. And though, as it stands, there's really no way to send the GPC signal either at the device level for mobile devices like smartphones or to apps generally. This is a significant gap in consumers' ability to utilize a universal opt-out mechanism when and where I think it really counts. But that said, there are some caveats, and there's little examples to the contrary. So back in January, Attorney General Tong and our privacy section chief, Michelle Lucan, highlighted the mobile DuckDuckGo browser app, and they actually created a short video walking through how to set that up on your smartphone. And so this app that's designed for tablets and smartphones supports consumers sending the GPC signal after toggling a setting in the app. And it was actually on that video, the AG noted that we think it's important for all apps and devices to begin to honor the GPC so that there's really a smoother continuity between how consumers are controlling their data on their laptop, their desktop, say when they're at home, but it also will track and reflect how they're controlling their data when they pick up their mobile device and they're going out for the day. Those two should be equally respected.
Are there conversations expected to be happening with some of those app providers some of the ones the big app providers that are likely to control the space and maybe aren't there yet with regard to the GPC?
There certainly are. And so that's in the commercial space, in academia, and we're certainly tracking those and contributing from our position as well.
Great. Awesome. And then one more question about, beyond your office's work, are there efforts being made to track and poll compliance to the universal opt-out? I think I saw a study that was done in California. It showed pretty high rate of compliance on the consumer side as well as on the business side. And it seems like there's a kind of a passion and a sense of urgency with regard to wanting to make this happen. I'm curious as to what you all are finding and whether there's been any research that suggests that there is a gap that's being closed with regard to the universal opt-out.
Sure. So to begin, I certainly should note that our office and more state AG offices, as their universal opt-out requirements come online, work hard to determine universal opt-out compliance. And even for folks that are listening, if you're interested, many of the browser extensions that you use to send the GPC signal also provides information about whether the site that you're looking at has accepted the signal, what third parties may be receiving data from that site, and whether the business is complying with your choice to opt out. But beyond this, there's actually really fantastic work going on right here in Connecticut. The Privacy Tech Lab at Wesleyan University has been conducting research in this area for several years. And they've actually developed software which can scan websites en masse to determine a website's reception to the GPC signal. This really, to the best of our knowledge, is really one of the only efforts going on in academia that's doing this hard and technical work of tracking and determining universal opt-out compliance. As you can imagine, tracking and enforcing universal opt-out requirements is not simple. It's not always straightforward, and it could become highly technical very quickly. So you really need to take time to parse the traffic that flows through a particular website, for example. But even during the first half of this year, as our privacy section in Connecticut has been shifting and focusing on this after our provisions came online, we've seen great developments in the efforts to track compliance, and we expect and actually can foresee developments certainly in the future.
Great. And one last question for those who are kind of privacy geeks and have been around since the 90s and the early 2000s. I'm curious about, the do not track movement. I've heard a lot about, how that was another very fervent, passionate movement, and then it sort of fizzled out. And I'm curious as to whether you think this is sort of the do not track 2.0 version, or how it compares. How does the universal opt-out control compare to the do not track movement of the, the 90s and the 2000s?
Well, Divya, this is like perfect question because I'm a privacy geek, but also a history geek. So it's fun to follow these movements. There is a historical connection. The spirit of do not track movement really has carried on with our current universal opt-out requirements, giving consumers control to automatically send a signal to a website that you want to browse without being surveilled. That's really like the underlying theme that you see. And in fact, there was even an earlier movement called the Platform for Privacy Preferences Project, P3P. And this sparked and fizzled out really in the early 2000s. Though Do Not Track was adopted by major browsers, and this was around 2011, 2012, the Do Not Track signal was largely ignored by web publishers because compliance was largely voluntary. The global privacy control is kind of like Do Not Track 2.0. It's specifically designed to recognize comprehensive data privacy laws, which Do Not Track did not do. And it's designed to specifically signal a consumer's choice to opt out of the sale of their data or targeted advertising. Whereas Do Not Track did not really trigger an exercise of specific rights that consumers may have. It's really this last piece which allows GPC to most closely align with the Connecticut Data Privacy Act. A browser extension that sends a GPC signal to a website, it clearly communicates that the consumer intends to opt out of the sale of their data or the use of that data for targeted advertising. So it's a significant step up, and it's timely with the passage of more and more data privacy laws in states.
Awesome. So it sounds like we found a solution that actually works, and it makes more sense, and it kind of is more fluid with the data privacy law. So it's kind of a glove, and it's just a perfect match in terms of what would work versus what's happened in the past, which started, stopped, and fizzled. And so it's nice to see that kind of fluid movement happening now, and businesses want to do it because they have to, and then consumers are now excited to use it too. Yeah, that's great. Awesome. Well, we're going to share all of the resources with the audience today after this, and we'll have that posted on our site. Really, really happy to touch on this topic and also give folks the practical side of the law. I think that's sometimes tends to be missing when a new law passes and you hear about it, you read about it on the news. You don't always know, how can I actually use this? So it's nice to be able to put that into practice today and talk through it. So thank you for joining us today, Jordan. Really nice to have you.
Thank you very much.
Yeah, it was a pleasure. And you were just a wealth of knowledge on the practical side of the law and what consumers are facing today here in my home state of Connecticut. So thanks for being online. And for those who joined us today, thanks for listening in. Have a great day, everyone. And please reach out if you have any follow-up questions.